Did you say?
Nope.
You're live. Welcome, everybody, back to what should be the Committee on General and Housing, and actually is in a moment. Today is still Thursday, February 5, 2026. We're taking up 459, which is an act relating to parental and family leave, which came to us as a short form, I believe. And this is discussion with our council. This is not a vote. So please, Sophie, you want to identify yourself for the record? Take it away.
Sophie Sadatny for the Office of Legislative Counsel. Is it okay if I go ahead and share my screen?
Please.
There was not a.
So as noted, this is currently in a short form. And the bill proposes to prohibit employers from requiring employees to take parental and family leave for a compensable work-related injury or illness. And last session, there was some confusion around what was intended by the bill. And I think there's been some clarification since then, with the goal being that employers not run, if a worker is out on workers' compensation, that their entitlement to unpaid leave under the Parental and Family Leave Act not run concurrently. So I thought I would just do a very quick presentation just to hopefully just situate everybody in what we're talking about.
Bless you.
Bless
you. I'm taking it back.
Thank you.
Oh, no.
Okay. Well, this sounds clear, but my computer decides not to allow me to advance the slides. Just pain. Okay, looked like it was about to let me do it. All right.
Welcome, Saudia.
So I just wanted to run through, so workers' compensation. I'm sorry. Workers' compensation is essentially a non-fault system that provides a remedy, and the goal is that it be quick and it's independent of proof of fault. So if someone's injured at work, they don't need to go through litigation to prove that they were injured at work and, you know, the employer was negligent or whatever. It's just an understanding that if you have an occupational illness or injury, you know, related to your workplace, you go through the workers' compensation system. And the quid pro quo for that is that then the employee, unless there's something really egregious that happens, doesn't file a lawsuit against the employer. So it's a way to balance that out and to provide something that works for both employers and employees. And again, if you have a workers' compensation injury, employers pay the expenses for the treatment that you need. You could receive replacement wages. Usually that's 2/3 of what you were earning pre-injury. And you might, if you're permanently injured, you may receive an award for impairment. If it's something that's you're never going to be 100% afterwards. And then Vermont's workers' compensation law provides for reinstatement within 2 years and protects workers from retaliation. I just flag that because that's not necessarily true in other states. Sometimes there is no protection for reinstatement included. And then the Parental and Family Leave Act covers the serious health condition of the employee. It does not need to be work-related injury. The cause of your injury, your health condition, is irrelevant under the Parental and Family Leave Act. The definition is, this is just how it's defined: accident, illness, injury, disease, or physical or mental condition that poses an imminent danger of death, requires inpatient care, requires continuing treatment by a healthcare provider, and then it also covers rehabilitation, which includes treatment for a substance abuse disorder. And then unpaid leave is for up to 12 weeks in a 12-month period. So these are two separate things. And I would also flag, and there's lots of different kinds of leave. So we're just talking here about parental Family Leave Act in Vermont and workers' compensation, but there's, there are other entitlements to leave that an have, like as a disability accommodation, is just a variety of other things. And so the responsibility for human resources, if someone needs leave, is to sit down with them and figure out what do you need the leave for? And it could be they might be entitled to it under state law, federal law, a union contract, or an employee's handbook. So just to be clear, this isn't the entire universe of leave. We're just talking about these two here today. So the issue in this is around concurrent leave. So typically what might happen is if somebody's out on workers' compensation leave, an employer could say, we're going to run the clock on your Parental and Family Leave Act leave as well. And that's pretty common. No state prohibits that, and federal law even encourages it. And I think one of the reasons it's encouraged is because there are benefits, and at the federal level, it would be under the Family Medical Leave Act, but there are benefits in terms of job protection, continuing your health insurance, et cetera. So there can be a benefit to workers to have it run concurrently. And so in order to have the leaves run concurrently, the employee has to meet the eligibility requirements for each type of leave. So, obviously it would have to be a work-related injury, et cetera. And so I think this is the situation that is sought to be addressed by the short form. Is currently an employee receiving workers' compensation benefits may have the time off if they're not working, they're receiving replacement wages, counted against the employee's 12-week entitlement to either under the state or the federal Family Medical Leave Act. And that effectively reduces the amount of protected leave that an employee is entitled to receive. So that's just the general context of where I understand this short form request to be coming from. Happy to answer any questions if anyone has any.
Wait, you said, if I understand, if I get injured on the job, so let's in a way that I'm entitled to workers' compensation benefits, and I have to be away from work for a month. Under workers' comp, I'm paid for my medical costs. Not, am I paid for my lost wages?
Right, so you would receive replacement wages, which usually is around 2/3 of your pre-injury wages.
Okay. And what you're saying is currently under federal and state law, in fact, it's encouraged under state law.
Under federal law.
My employer can say, okay, you're going to be gone for a month. That counts against your 12 weeks of parental and family leave.
Right, because you're out for a serious medical condition. So we're going to just run it concurrently. So you'll get paid. The PFLA is unpaid. And so, yes, you would run the leaves concurrently.
So the leave is 12 weeks a year.
Under the PFLA, you can have up to 12 weeks.
Right,
in a 12-month
so-
period.
Not always though. So you have sorry,
That's fine.
so you have up to 12 weeks, but hypothetically, and not like a workers' comp situation, but I'm trying to think of a good example. I don't know, you stub your toe and you break your toe, but you sit at a desk all day. Your doctor can say you need to be out of work for 2 weeks, and then you would have the remaining 10 weeks.
Right, what's left?
Yeah.
But when would you, presumably to use that extra time, it would be something else that happened.
Right,
Yeah.
right. And again, what happened in the last session was there were a lot of other reasons that somebody could use the Parental and Family Leave Act under state law. So it could be bereavement leave, safe leave. There were other things that were added in to that.
Right.
And again, it can be, your child is sick and needs to go to the doctor, or your parent is sick. So there are other uses for the PFLA.
So you've used, under the concurrent approach,
Right,
you've used up part of your family leave.
right, that's available to you. And
FMLA.
again, we're not getting, because you have to
Right.
be eligible.
Right,
you
yeah.
have to work to certain.
So what is this bill?
So as I understand it, and again, it wasn't entirely clear last session, but as I understand it, what the short form bill is driving at is to not allow employers to run a workers' compensation leave concurrently with parental and family leave, or vice versa, run PFLA at the same time as you're running the workers' compensation leave. That's what I understand the issue to be.
Do you have questions?
Okay, that's a little bit off topic for that, but if someone is using bereavement leave, that would be workman's.
No. So workers' compensation is in one bucket over here, and then parental family leave act is in a separate bucket. And right now, if you're out of work for a qualifying reason for both buckets, you can run that time concurrently.
Okay,
So if you were out on bereavement leave for, I think it's up to 2 weeks,
okay,
then you would have 10 weeks left of PFLA. But then if you're out, and then if you had a workers' compensation injury, what an employer can do is say you're out for 2 weeks for your stubbed toe, broken toe, whatever, that would then be another 2 weeks that would come out of that 12-week bucket that you have under the parental and family leave act.
so if you're out because of work on workman's comp or the bereavement, it's the same as if you were still employed.
Right.
So do you have all the benefits, like medical benefits and?
Right, so under the Parental Family Leave Act, it's unpaid leave. So essentially what that's doing is providing job security, that the employer will hold your job while you're out on that leave. And that the employee can continue to receive medical benefits that they receive through their employment. They would still have to pay their share of the premium.
Right.
Vermont, under the workers' compensation statute, there's also a reinstatement provision that if you can return to work within 2 years, the employer will give you the next available suitable job for you. They don't have to create a position for you,
Mhm.
but if you were, doing some kind of job and they've got an opening for that, then you would get that job over anyone else that might. So there is some reinstatement provided for you under the workers' compensation statute, which is not true for all workers' compensation statutes around the country, because workers' compensation is done as a state issue. And I think that this would be speculating, but I anticipate that being why the federal Department of Labor actually encourages employers to run these concurrently, because if you run them concurrently, then someone else on workers' compensation is getting those added job protection benefits
Mhm.
that come from the Federal Medical Leave Act. And I just want to make sure the committee is aware that in Vermont, there already is that protection in terms of having the ability to be reinstated within 2 years of your injury.
Thank you.
I think, Mayor,
I worked in the Human Resources Department for a utility, and I handled the insurances and the workers' comp. And just like Representative Bartlett said, if you can come back to work, let's say within 2 weeks, you can either, if they filled your position, let's say while you were out, they will offer you a similar position. You won't lose your job, but you will have a different job. Same thing if you were out on maternity leave, when you came back, if they had to fill your position, you would be offered something similar. I think this is a good bill. I think it should be separate.
So, okay, right, so you
I-
can't stack them. I mean, you
Right.
can't do the concurrent.
I'm just saying, as a state employee, when my husband was sick, I could not take family leave because I didn't work enough hours for the state. So, they have different
Eligibility.
eligibility.
Tom and then Ashley.
If you have a full-time employee with benefits and they are on workman's comp, they're on leave. I'm assuming the employer is still paying benefits and they have a family health plan.
Right, I think the employer may still have to pay their share of the premium, but they'd still be covered. And again, any bills related to the work-related injury, the employer would be covering 100%. And the employee would not be covering a portion of that.
Right. Right, the benefits are what I'm looking at the moment. So during the unpaid 12-week leave, the employer is also still paying the benefits.
Right, and again, the employee is sharing, paying their share of the premium.
So potentially, it just be, there's part of my question concerns the cost. Okay, the employers are not bottomless buckets of money. Some of these businesses run at 5 and 10% margins. So if you have an employee who's unable to be there, not opposed to taking care of them, you have to still earn enough money to pay those bills, and you're short an employee. If these are not allowed to run concurrently, then there's hypothetically not much of a limit to how long they can run and how long the business needs to come up with that revenue to pay those benefits without that employee there.
So if someone's out on workers' compensation
Right.
and they're out for, let's say, 6 months, and you run the PFLA concurrently with that, then, you know, it's, that clock is run, so there's no additional benefit under the Parental Family Leave Act. If, so it doesn't, it, essentially what this would do is just say that, you know, your workers' compensation, you could be out, again, you have reinstatement rights up to 2 years. You could be out for a long time on a workers' compensation claim. If you're running them concurrently, the PFLA, the clock's run. I mean, it's done.
Yeah,
You're
we're
just then
suggesting-
dealing with the workers' compensation.
We're suggesting not doing that, right?
Right, so what this would do is then if and when that employee comes back to work, they would then still have the eligibility, although I mean, actually, that is one question I don't know is because you may have run out of hours, you may not have worked enough
So
to qualify for the PFLA.
can I comment on a few of those things? So, when you're in workers' comp.
Yeah.
I'm so sorry. Nothing, sorry, excuse me. When you're on workers, when you're on workers' comp,
That's right.
I am very sorry. When you are on workers' comp and you are out of work, you're only getting 2/3 of your pay. There have been times where employees called their employer and said, hey, I'm good to come back. An employer cannot reinstate you until your doctor has certified that you are okay to come back. My understanding of that situation, separately of what Sophie just brought up, if your doctor has said this person is cleared to come back, you're not going to qualify for or PFLA because your doctor's not going to certify any of that, if that makes sense, because there's no longer a medical condition because your doctor has already certified that you are fine to come back to work. That being said, the way the hours are calculated, I don't believe if you've gone through your, I think after the first year, probably, you wouldn't have enough hours to qualify for PFLA to come, when you come back, to add that on to your workers' comp.
Okay. But the entire duration of the workers' comp leave, the employer is still paying whatever contractual benefits they have for that employee.
Correct. But that's what it is already.
That's workers' comp.
So that,
That's workers' comp.
I mean, this is simply just, it's just simply that concurrent issue with the, so right now employers can run, again, assuming the employee qualifies, you know, for both types of leave, an employer currently legally is allowed to run the clock on the PFLA or FMLA at the same time that somebody's out on workers' compensation. As I understand it, that's what the goal of the short form is to say you can't do that. And that once they come back from workers' compensation, again, assuming they qualify and meet the eligibility requirements for hours, et cetera, they still would have that pool of 12 weeks of unpaid leave available to them under the PFLA.
Do we know where that threshold is when they run out of hours to qualify for PFLA? What I'm trying to figure out is.
1280.
Which is a little more than half.
Okay,
Yeah.
1250, between 1250 and 1280.
Okay, so
hours a year.
For that particular employer.
which is kind of like a little more than half time. So if somebody's used up. Okay, just go ahead.
With it the way, so I'm. We're potentially extending the cost of the employee being at work. It's money the business still has to make. So if they're out for 4 weeks, they come back,
Mhm.
they can still qualify for
12 weeks.
12 weeks. So now that's,
But that's. Correct.
so if we run concurrently, there's up to 12 weeks. So there's 12 weeks, and yes, the employer is going to be paying benefits. If it's worker comp related or not.
Mhm.
But potentially what we have, if we don't run concurrently, is the employer paying the benefits package during workers' comp, and then again for up to a certain number of weeks, so depending on how long the leave for workers' comp is. That costs almost as much as the labor. So
But what I was trying to say is, in order for you to come back to work, you
Yep.
have to be certified by your doctor.
okay,
The Leave Act could be for a range of other things
Yeah.
other than being hurt though.
Yeah.
So you could be perfectly fine and then 2 weeks later you take it for a
For a
completely different
Yeah.
reason.
different reason.
And that's what this bill is trying to.
Yeah.
Right.
In fact, that's the I think, I'm sitting here trying to think, what is the rationale for this?
Yeah.
And I think the rationale for the change is workers' compensation is for one thing, it's for a worker who gets hurt. And that's paid, although not fully, it's paid. You know, and your health care is paid and your benefits are paid. It's as if you're at work
Right.
at 2/3 salary. Rental and family leave includes a whole bunch of other stuff way beyond whether you're hurt on the job. It's about parental stuff, bereavement, et cetera. I think the theory behind the bill, I'm not sure how I feel about it, the theory is they're separate, so keep them separate. In other words, they're not the same benefits, so they shouldn't run together. I guess that's the theory behind it. In terms of cost, which is what you're getting at, the only thing I'd say is workers' comp is it's costly to the employer because their rates go up and they have to keep, and does the employer pay for the medical and all the benefits?
Usually an employer will purchase insurance.
Yeah, and so,
But again, if you have a lot of injuries in your workplace, your cost of your
Right.
insurance is going to go up.
right, so one way or another, it's either picked up by the employer, I'm talking about.
Yeah.
But on the other hand, parental and family leave, my understanding is you don't get paid. And you have to pay, you get your benefits, but you have to pay for it.
Well, you pay,
Is that
Yours.
you just pay your
Yeah.
share of the
You
premium.
pay, oh, you mean the employer continues to pay
Mhm.
their share?
That's where, so that's where for like the small shop.
Yeah.
Employer. Just having somehow, being able to anticipate what will this cost in the calendar year is much more open-ended.
I think, the other,
So,
it's unpaid leave under the Parental and Family Leave Act, so it's not something that people can, a lot of people can't just take 12 weeks of PFLA. But from the employer side, obviously it's, particularly a small employer, it's disruptive, right? You're losing an employee and you only have, 10 employees and you lose one for a period that's disruptive, just as if you use the workers' comp as well.
If it would be helpful if we decide, to have some testimony on this, we could hear from the people who were the catalyst for this request, who came to the legislators who submitted the bill, and then also from some business folks if we continue to move forward.
That's the question.
Yeah, how do?
The question is, how do folks feel? Should we ask Sophie to draft this up and take testimony or not? It won't happen right away in any case. we're pretty full for a bit, but it could happen later. Or do we do that or not? That's the decision today.
I see myself in any place. Drafted or not. Representative Charlton brings up, I think, the sticking point for me, which is like great to like feel good bill, like, yeah, I get it, like they're two completely separate issues. But there also can be the exact same issue where you're on leave because you're injured. And you're on leave because you're injured. How many clocks do I have to run at the same time, or does every clock get its own start date and end? And if you're a huge employer and can absorb the cost, excellent, you're probably going to be fine. If you run on the margins and one of your tactics to get good employees is that we offer really good benefit package, it's taxing on the employer to do it, but that's kind of how they recruit people, is with a good benefit package. That's going to hurt. Because I don't know if people have seen benefit package costs lately, maybe education or other things like that. $40,000 a year for a benefit package that the employee pays 5 to 10,000 of that. That adds up real fast with a small employer.
Both of you guys. One after the other. Go ahead, Gail.
So is there a possibility of in policy stating something that for businesses that make under a certain amount, this does not apply? Is that not equitable?
So could it be limited by number of employees or something?
Can we
And
do that?
without too much transparency, or maybe I am, the catalyst for this bill is a very large employer.
So maybe we need to,
Of why they came to the
Provide that.
sponsors. I just want that.
The
Which
benefit,
is consistent with your fear, which is that
for
small employers can't handle it.
Large employers always want more.
it's part of the benefit package that you have workers' comp and
Yeah.
family leave. And obviously you don't want to have anybody injured on your premises, but if you don't offer workers' comp, then you might have run the chance.
You have to. I'm just trying
So-
to figure out how long a clock could hypothetically run while I'm paying the benefits package. It income that one. Me. That's, I'm not where I can find any workers' comp. I'm the benefits package. It's taking something that used to overlap, now potentially putting it end to end. So I'm just trying to figure out how long. Because it's. Yeah, I mean, if it runs a year, you could hire another part-time employee.
Yes,
So,
or do some cross training or,
Would you feel comfortable if there was an amendment offered for a very large threshold of a business?
other business size thresholds for other HR type things.
Yeah, I think we had them in this committee.
Yeah.
And I think, I had a question.
Go ahead.
Can you tell us about the thresholds about, because I thought that the unpaid family leave act was like 50 and under, which is gonna cover most of Vermont.
So under the Parental and Family Leave Act, an employer needs a person who, for purposes of parental leave, well, all the different leaves, employs 10 or more individuals who are employed for an average of at least 30 hours per week during a year.
Is that federal?
This is our state one.
State,
I was
which
talking
one?
about the federal. Yeah, federal is 50, but we've made one that's.
Right.
So
ours
that's
is
the
10.
floor and ours is higher.
Right, so ours is if you have 10 employees working at least 30 hours a week, then you're a covered employer under the Parental and Family Leave Act. If you have 15 or more, that's for the family leave, that's the maternity, child leave. But yeah, so right now there is a threshold on the size of the employer. But again, I think if you were adding something in, you could have a threshold that was specific just to the current piece.
Right.
How would people feel if we just asked Sophie to draft it up? But to contain a provision that would have a size cutoff and you could just leave it blank. And tell us different size cutoff.
Yeah, and I want to do a little research too.
Yeah, it could be,
Started, yeah.
yeah, it could,
The federal, yeah, maybe the federal cap.
Yeah, let's do that.
Could I ask a question? Could, if it- your job is much harder than mine and I wouldn't know how to do it. If you're drafting the language, could we ensure that it would not prohibit any other types of leave running concurrently? STD,
Right.
I just like want to make sure that language is very clear that you might still be on.
workers' compensation.
Yeah. Please and thank you. STD is short-term disability.
Yeah, thank you.
Thank you.
Short-term or long-term, I hear.
Oh, my.
what I'm hearing is that the committee has,
It's not Friday.
Kathleen, you wanna turn your computer or mute your computer?
We
Kathleen?
got the sillies today.
Okay. What I'm hearing is despite, I think uncertainties would be the minimum way I could put it about the substance of the bill. I think you should go ahead, that there's enough feeling about it. You should go ahead and draft it up, but draft it up with a size threshold that we can then debate. And then when you come back, perhaps with some examples of size thresholds, 10,000 employees or
Right.
more, you know, whatever.
Maybe.
Let's remember that a majority of our businesses in Vermont have 10 employees or
Yeah,
less.
that's right.
That's.
No,
Um,
I'm trying to go after the big guys.
Go.
All right, I'm done.
All right, thank you very much. So we are now going
Thanks,
to
Sophie.
return to to H 772, which is an act relating to residential rental agreements, eviction procedures, and creation of a positive rental payment credit and reporting program. And our next witness, Jean, you can sit down. You know how it's computer connected.
Yeah, when I'm a little nervous and I'm a little nervous, technology takes me a little bit longer.
Take your time, please.
I can do limited. Just those conditions. Over here.
Did you?
No.
1:30.
See who I don't. My computer is as nearly as old as I am, so I have to plug it in, or it might just abandon me. Visuals and Chromebook. Some kind of bill there? It works pretty well, except for the back of the part. So I'm trying to open
Take your time.
the email so I can get the Zoom link. Miriam sent me earlier.
Oh, Jean is fooling the technology. She's our first witness on this bill. This afternoon, she's the senior housing attorney, I think the senior housing attorney at Vermont Legal Aid. I can tell, I know what senior means, but I won't comment on
Which
that.
definition of senior is.
And after Jean, going to have a break, and then we're going to have testimony from 3 more people before the floor at 3:30. Right, Kathleen is,
And then
right, I'm sorry, Kathleen Burke. from the housing authority. You need help? Because we have a person here who is of an age that means that she's very technologically savvy.
We need a youth.
Yes.
We-
Yes.
You need
My cousin
actually
Vinny.
2 years.
2 youths.
You want to help
Great movie.
make sure that
I got to the Zilling, but now what do I do? You hit the button.
Is that probably gonna have to go?
Okay.
You want me to?
Okay, there we go.
I mean, I think the governmental affairs person has to explain why your technology is not sufficient to deal with our system.
Okay.
That's kind of cool.
Yeah, would you like that in court where it's
Okay. I- This up on the screen and then
Here are the screens. Is that working?
that is, you might want to use the little thing there to make it big.
I wanna take the side thing away. How do I make it bigger? Oh my gosh. I'm so sorry.
Don't be sorry.
No.
You made it farther than me, so don't feel bad.
We're going to start you from the beginning. You all set? And then you can just hit this right here. Oh, perfect. All right. Okay.
Want to tell us who you are for the record?
For the record, my name is Jean Murray. I work at Vermont Legal Aid. I've worked at Vermont Legal Aid since 1998, when Angela was first out of law school. She and I met in court and we've done trainings together. She's a really nice person, and I was here when she was testifying. One of the things that makes me nervous is this, my whole career, 35 years, I've stood up for tenants. Now looking at this bill, I feel like I need to stand up for Vermont. And it kind of makes me nervous because what's going on here are housing policy choices. So you guys aren't, I'm seeing them. Okay. What is the problem that we're trying to solve here with amending landlord tenant law? You've heard from other people. I saw your agendas early in January. There's a housing crisis in Vermont. There's not enough housing. The housing, especially the rental housing we have, is too expensive for the people who live in Vermont, for people who live in Vermont forever. My data, my information comes from representing tenants. I did a thing in our database to find out how many tenants that me personally has talked to who are facing eviction in court in the last 3 years, and it's 359. And one of the things that I do when I first meet a tenant is I Google them and I find out, I look at the online docket, I look at to see if they show up on Google anywhere. The place that most of my clients show up is in somebody else's obituary. So they are a relative of somebody who's lived in Vermont for a very long time and has passed away, and they're the people who are remaining. The people who don't have enough money to pay the rent in Vermont are Vermonters. So for me, the problem that Vermont is trying to solve is housing affordability and rental housing availability. And we need to solve the barriers to people who are trying to exit homelessness. So one of the things I wanted to do was what they call level set. What are we trying to change? We're trying to change the landlord tenant law. Where did the landlord tenant law come from? The landlord tenant law came from legislative discussions in 1985 and 1986. It was effective in 1985. And it was passed as a whole policy in Vermont to balance the rights between landlords and tenants, to protect tenants from unscrupulous and recalcitrant landlords. In 2019, I turned it into a lease. And so if you want to see the whole of Vermont landlord tenant law, I'm passing it around right now so you can see what it is. You could use the Residential Rental Agreement Act as a lease, which is maybe the most important point. So over the years, since 1986, what has changed? In 1986, the vacancy rate was 7%. The vacancy rate now, and this I disagree with Angela on, is only 2.5%. The vacancy rates in the other states that Angela was talking about, they are much bigger vacancy rates. So right now, because Vermont doesn't have enough housing, the vacancy rate has flipped. The Residential Rental Agreements Act based balance on how people behaved in the market. But scarcity has tipped that balance in favor of landlords. It's meant to protect tenants from unscrupulous and recalcitrant landlords. In my written testimony, I give you the Supreme Court site that says that. But the lack of tenant lawyers means that the current law is not enforced. You can pass all the laws in the world, but if there's nobody watching, they don't have to be followed. And believe me, there are landlords out there that do not follow the law. Sometimes it's because they don't know the law. But then I would say, if you don't know the law, what are you in the business of being a landlord for? You need to know the law. You need to understand how it interplays and what the duties and the rights and duties are. And sometimes they just make mistakes. Sometimes they don't understand what they have to do. Like, for example, when we're talking about the time needed to adjudicate even a non-payment case, a professional management company with professional software did not keep a ledger of, on this date, this much was owed and this much was paid. But they kept a kind of changeable spreadsheet. And so the way I found out is they attached a ledger at the beginning of the case, and then I did discovery and got another ledger. And I said, look, if we look at this date, on this one, these transactions happened. But on this piece of paper, these transactions happened. You mean you didn't actually keep a record of when payments were made and not? You went with your computer and went back and changed the records you kept? And this is a professional management company. So they don't mean to be unscrupulous, I suppose, but the ability to be careful, it's not always there. And the Landlord Tenant Act was meant to assure that rental housing is safe, clean, and fit for human habitation. But in Vermont, we used to have town health officers. The town health officers were not necessarily trained as building inspectors. The health department tried to step that up, and ultimately the Department of Public Safety took that over, and now they have a complaint-based system and they have professional people that will come out. But if the tenant never calls, then there is no guarantee in most of Vermont that the place that they're renting is safe, clean, and fit for human habitation. So is the current landlord tenant law doing what it's supposed to do? Among anything you're talking about here today, I would keep it, but if you actually wanted to sit down and talk about how I think it could be improved, I could give you some ideas. So who are the stakeholders in this landlord-tenant situation? In my written testimony, I say I identify landlords, and a subset of landlords is managers, property managers, and then there are tenants, and then there are the human service. You heard from CDOEO this morning, but all of the CAP agencies and the elder service agencies and everybody who tries to help people stay housed. And those are funded, by the way, by Vermont. They're funded through Agency of Human Services, not entirely funded, I don't want CDOEO person. But they're funded through Agency of Human Services from the Office of Economic Opportunity, who gets a grant from the legislature and turns around and says, here's money for staff, here's money for back rent. So see if you can see how many people you can keep housed with this. So, and the reason I want to point that out is because when you take things away from tenants, and on this hand, you're paying to have people help tenants, that money that you're spending becomes far less effective. So, but okay, I was landlords, property managers, tenants, human services providers, and the judiciary. So those are the stakeholders, and I'm going to start with landlords. You may have heard when people, especially Maura Collins from Vermont Housing Finance Agency, tells you how many units are needed, how many affordable units are needed, how many subsidies we have, how many subsidies we need. Kathleen's going to tell you that they're in a desperate spot about subsidies, that we're standing to lose some of the vouchers that we have because of financial things, and hopefully she'll explain that better than I can. But if you take away everybody who might be living in subsidies, then what you have is 65,000 households who are housed by private landlords. And some of them are mom and pop landlords, and some of them are corporations.
Yes.
I had this question earlier, and I hadn't asked, but I feel like you might be better equipped to answer it. Do you have a percentage breakdown on how many landlords are corporate versus, smaller mom and pop?
Okay, so here's my plug. The first time, I'll probably do it 3 more times, for a rental registry. No, we don't know that. There are marketing reports and there are newspaper reports about the increase in investor owners in Vermont, and that's part of the housing needs assessment too. That investor owner is defined as somebody who owns, I think, 3 or more properties, and those are growing in Vermont. But we don't know exactly who is the owners of places and how many units they have, and whether those units are available or vacant, or how much rent is being charged, or how many times did you ask the people there to leave, and when's the last time you renovated? We don't know any of that. And so, as Chair Mahali pointed out earlier this morning, when you're trying to make a decision on this, I would say that mostly you're not making a decision based on data of the landlord side. You're making a decision based on some landlord stories. And I was on the landlord tenant study committee. There are some landlord stories. But let's get back to just discussing landlords a little bit. There's 65,000 private landlords. I looked up the marketing data. There is many buildings bought this year as there was 5 years ago. There was a spike in 21 and 22 where double the amount of buildings were bought. So people are buying multifamily buildings, must want them for something. I imagine they want them because they want to be landlords. And I also am very familiar with foreclosure numbers because legal aid helps with foreclosures too sometimes. And foreclosure numbers are very low. Non-residential foreclosures are non-existent. I went and checked bankruptcy statistics. For Vermont, only 262 bankruptcies were filed at all. And it did not appear that very many landlords were declaring bankruptcy, and yet they've raised the rent. Now, when I say they've raised the rent 40% in the last 5 years, that is the average raise of rent. Some people's rent went up more than that. My rent went up 40% in the last 5 years. The sales prices of multifamily buildings have gotten 71% higher. So the value of the investment has gone up.
Sorry to interrupt, hello. Do you think there's a correlation between the costs going up on buildings and other tax related things to the rents going up?
I would suppose. And
It would seem like it's
so when you're trying to figure out a policy question, I mean, I watch a lot of TV, they follow the money. Who is making the money?
right, no, I know, I'm just saying my point, is it has to be a correlation of costs going up due to costs going up to the landlords.
I guess to piggyback on that, I think the question she's asking is what about net profit? In other words, if rents go up 40% and costs went up 40%,
Right.
the landlords wouldn't be making any more. But so she's asking, do you have any opinion on the rate of increase in costs?
I guess I have an opinion on it, which is that Vermont allowed itself by not building enough housing to allow people with a bunch of cash money to come in and buy pieces of Vermont and make it more expensive for Vermonters. That would be my opinion. Do I think that the rents across the board going up that much are directly related to all of these people who are deciding Vermont property is cheap and they want to invest in it? That's actually not what I think, but I don't know. I mean, I'm not an economist. And so I don't know. All I can do is.
I don't think you should be afraid to express an opinion, since we hear plenty of opinions, and I'm not sure how much else there is.
And one of the other things we know about landlords is landlords, and a couple of years ago, it was actually a fairly dramatic statistic. 70% of housing choice vouchers went unable to lease up because landlords simply wouldn't take them. I think that statistic has improved since then, but it was pretty bad for a while there.
When was that?
3 years ago during the pandemic. So,
But it's, if I may, you said 70% nationally.
no, I didn't say nationally. I thought it was us. I thought it was something from you.
We'll wait till your
Anyway,
testimony.
Gail had a question.
Gail, you have a question? I'm sorry. Thank you.
So my question is, don't you think that if we don't level the playing field and really take a look at landlord and tenant, then it's gonna make it that much more difficult for landlords to want to provide rentals?
No, I don't think so. I think somebody who doesn't want to be a landlord and figure out how to, because landlords make money in two ways. One, they invest in property and the investment value of the property appreciates. And they also have tenants to pay the expenses, including the mortgage, but pay the expenses and the maintenance while that property appreciates. And so should landlords be making a profit on rent? Well, they're going to make a profit on the appreciation of their investment in the property. So do I think that refusing to give landlords more rights is going to discourage people? Well, yeah, it'll discourage some people, but people who are business people and they want to figure out how to make this investment and manage the investment, they're going to do that. So at this point, when I look at this legislation, I think landlords want more. They want to have legislation reduce their expenses and their risk of expense. They want to blame all tenants, which there's 80,000 tenant households in the state of Vermont, which is actually 30% of all Vermonters households. They want to say, let's change the rights of all of those people so we can reduce our expenses. And they want to blame the court for delays, even though the courts, and I don't know if you guys know this, the courts process evictions faster than any other kind of civil case. Their aspirational goal is to make sure that the case is disposed of in less than 180 days. And they make that goal 78% of the time. That's from the judiciary statistic.
I'm sorry,
Okay.
can I interrupt real quick? I want to go back to this bullet point of have refused to take tenants with subsidies. Am I misunderstanding? I thought that's against the law.
Right, but if you don't have any lawyers to sue them, and if the Human Rights Commission is not funded enough so that they can investigate those cases, then people can get away with it.
But I guess my comment is if we're talking about blaming all tenants, isn't it kind of blaming all landlords? There's a lot of great landlords out there. And I guess my concern was saying have refused to take tenants with subsidies, like that's already against the law.
True, and yes, the reason I put these things on my bullet points is because this has been my experience as a lawyer for tenants. And trying to be here in this state house saying, what is it that we need to have a balanced policy about housing?
Yes, go ahead.
It's unsettling to know that even with a law on the books, those rates can be achieved.
For example, I'll name names because they've come here and talked to this committee before. There's a management company called, I think it's Stone and Browning. And if you go on their website and you try to apply, their criteria is that your income has to be 3 times larger than rent. And will they let you say, hey, I have a voucher that's worth this much money or would be worth this much money? Can I count that as income? And their application says no. So that is how they don't take tenants with subsidies. Because they say the only way you're eligible for a unit is if your income is 3 times the amount of rent on this unit. So
Gail.
What you had said before about it being against the law, is that across the board? Like if somebody owns a duplex or a quad and they rent, is it against the law for them to refuse a subsidy or a voucher?
We have an attorney here who could answer that, but that was my
I think what we
understanding.
should do is, Kathleen, would you note this issue so when you testify, you can address it? The whole issue of the legality of refusing to take Section 8 vouchers. She knows that issue. She'll be addressed. Okay.
So of the stakeholders, tenants right now are not doing fine and they are trapped. I'm trying to use the thesaurus as much as I can, but they're stuck. There's no place to go. Wherever they are struggling as hard as they can to stay there because there's so much scarcity in the market. There's no place to go. I call that trapped. Rental housing scarcity means there have been huge rent increases. There's no availability. There's no bargaining power against junk fees. Have you guys heard about junk fees? Where, you're going to get a concierge service along and so your rent is this, but you need to pay $35 for that and $23 for that and on, and you don't get anything for it. They're just surcharging your rent. Tenants are chilled from complaining about bad conditions or bad landlord behavior, because if they do, now you talked about retaliation earlier today. Sure, if the landlord turns around and tries to no cause you out within 90 days of you complaining, you can defend yourself with retaliation, but if they wait till 92 days, you don't have that protection anymore. So people don't want to complain. New workers can't move to Vermont. I think, and we've talked about problems in healthcare and problems in getting teachers and things like that. They can't find a place. They can't move to Vermont. And this is my opinion, based on the cases that I've seen. There have been more evictions because new landlords have come in and they want to renovate, so they just evict the tenants.
I gotta tell you, I'd say max 5 minutes.
Okay.
Okay. We have
Okay,
We have one more witness before 2:20. So we're,
so there is the problem, though, of the really bad tenants, and you're gonna hear more about that, but this is what I would say about that. Creating homelessness does not solve security problems. All tenants don't create the security problems. You don't need a law to change the law for all tenants. What are the alternatives to eviction without due process, which is really what the show cause part of 772 does? It really eliminates due process, I think probably unconstitutionally. Alternatives could be security. Yes, it increases the cost of some places, but the cost is the cost. Roofs cost money too. I don't think you say there's no way to solve security problems until you've tried to make sure that there are security buildings. Law enforcement has a role in this, and people should be talking to law enforcement about what it is that they're doing to keep the proliferation of, I guess, drug dealers and criminality out of housing. And then, of course, I think there should be more housing retention, early intervention services. Shortening notice times for tenants will not make courts move faster. It won't. The courts are going to move as fast as they can. In my written testimony, the judiciary is my branch. They are the place where people can go and be heard. And the judges take it very seriously, and they try to give each case the time that it needs. And they are under-resourced, like everything else. I'm sure if you had somebody from the judiciary in here, they would say, if you gave us more money, maybe we'd have more judges, maybe we'd go faster. But the court, taking the rights away from tenants is not going to make the courts go faster. As CVOEO said this morning, short notice times is just going to mean that you're not going to be able to get help. One of the really things that I think has gone not good in 772 is taking away the time to pay and stay. The policy in Vermont has been, yes, you get behind, but if you catch up, you can preserve your tenancy. And right now, there's a certain amount of time to do that. And this takes away time to do that, which seems backwards to me. I think the thing that is being proposed here, the most telling thing to me about this is adding grounds for eviction under the violation breach part, non-payment violation breach. In 772, there's a paragraph that says, if the tenant doesn't agree with the landlord's changes, that is now under 772, a violation of the statute. So what that means is this is legislation directed at taking away tenants' bargaining power. And for me, that frames the whole intent of this legislation is to make things better for landlords and make things worse for tenants, which is going to set up a situation where it's ever increasingly more okay to take advantage of tenants. I don't think that's good for Vermont. I think people will not come to Vermont if they can't find a place to live. What happened? Yeah, and then there's other embedded things in 772. Right now, a complaint is allegations and a answer is cross allegations or their version. Complaints do not have to be verified under oath. They're actually not even supposed to be. This is not the evidence. A complaint is not evidence. The answer is not evidence. It's just stating your positions. 772 says tenants have to answer under oath, but landlords can come to court and say, this is what I think is happening, which is fine if you have time to adjudicate it and say, okay, prove what you think is happening. That's fine. But 772 takes away tenant right to be able to present their case. It says if your affidavit doesn't meet snuff, you're out of here. That's more profound in the show cause piece, but it's also part of an eviction for every tenant. One of the things that 772 does, right now there's actual notice, and the words of actual notice are, actual notice is the receipt of notice. And then it suggests, and it says two ways. You can put it in first class mail or certified mail, or you can put it in the tenant's hand. And in 772, the word receipt is taken out. That means that it's valid notice and you can go to court, but you do not have to prove that the tenant received it. And I'm just to me mind-blowing. So other states may have the shorter notice times, but other states' notice times fit with the housing policy choices that those other states have made and paid for and improved. Other states have housing courts. Other states have trained housing mediators. Other states have building departments that regularly inspect places. To a lot of places there, you need to have a certificate of occupancy to rent. Certificates of occupancy, wow, that would mean that there's someplace to look to see what is the rental housing here, who owns it, how much they're charged for it. In other words, a rental registry. Other states ensure tenants the right to adequate housing, and even though the law does, we can't enforce it because we don't have enforcement mechanisms and tenants don't have lawyers. So other states protect elderly from no cause eviction. Other states have court eviction diversion. But what works in this? I'll go down the side that I think that 339, 440, and 772, to the extent that they picked up things in 339. And there's one in 688. 688 would change a rule about mediation. It would allow mediation in landlord tenant cases. But what works? Limit eviction for no cause. That is not serving Vermont. Somebody said, how many evictions is this for what? So we were able to, with pandemic money, do outreach, all the tenants facing eviction. And so that was 5,000 tenants over 3 years, and 2,500 came back to VLA and LSV. We don't have that money anymore, but for the time we did it. So we were able to basically track what was the reason for evictions. And so 70% of them for non-payment of rent, 72% of non-payment of rent, and 22% were for no cause, which was greater than the last time we did a count, which was from 2016, where only 17 or 18% were for no cause. And 7 to 9% were for cause, but most of those causes were not violent problems. They were, you didn't get your paperwork done.
I'd have to ask, because we're really cutting into the time of our subsequent witness. I see these lists and they're very valuable. Maybe you just want to pick one or two of the most important things there. We see the list, and I think it's safe to say at this point know what they mean, but feel free to comment on one or two, and then I'm having to ask you to wind up.
Well, if it had not been for this bill, I'd be back in this room asking for more back rent programs. Back rent programs work. Kathleen's going to tell you about them. And I'd have a tenant right to counsel. I would keep eviction records confidential. There would be a rental registry. There'd be more of this. I'm going to read my list. There it is. These things are important for what the problem Vermont is facing now. And so if we wanted to sit down and have a rational discussion about what are housing providers going to do about the tenants or the guests of the tenants who are destroying some buildings, we should do that. We should have that discussion. I don't think that's contained in 772. I really appreciate all your time.
Thank you, and I'm sorry there isn't enough of it. Questions?
Just one question would be, it's very obvious that we have the people being evicted and the landlord side of this whole argument. My question for you would be, how much work does your group do with the people that live on either side of the person being evicted? We talk about tenants' rights all the time, but some of those tenants are perfectly fine in the buildings they're in and are having their lives flipped upside down because of the person next door. How much work does your organization do with people on either side of the person being evicted?
Well, right now I have a case where, my client is a single mother and she's living in housing built with public money. And her upstairs neighbor is going through some substance abuse problems and is very loud and is just, so she's not rational and she does stuff like jump on the floor, which means that my client can't sleep at night. And she is trying to have a business that requires her to have a lot of energy. And she lost, it's a house cleaning business, lost clients because she wasn't able to get there because she couldn't sleep. She's asked management to do something about it. Management won't do anything about it. And this is not somebody this is not a foot traffic person. This is just a person whose behavior is not good and is disrupting the other tenant. And the reason she's my client is because management is evicting her. So do I see that? Management's not evicting her because she's complaining. Management is evicting her because she's behind on her rent. She's behind on her rent because the other tenant disturbed her and she lost business. So do I see both sides of it? I do see both sides of it. But there are ways to deal with both of those sides and like deputizing landlords to be the arbiters of whether or not somebody has broken the law is not really the way to go.
Other questions? We're really running behind, so true questions.
Really quickly, just on, can I piggyback off of that? And sort of, and if you can just decide if this is for Jean or Kathleen to answer. Similarly to that, when folks are in a residential situation where there's disruption, so I'll give a specific example. Similar situation, apartment unit, the upstairs neighbor literally terrorizing the downstairs neighbor, cutting their cables, flooding the bathroom so it leaks into their apartment, stomping on the floor. Very similar situation, but both apartment units are on vouchers for people with disabilities. So and so of course the agency that is the housing infrastructure, who I won't name, has not evicted either tenant. Are there legal recourse for damages or anything, or like how does that work with the tenants just being like, because part of it on your first slide it said to provide safe housing where there's not disruption, and I think that's what we're talking about.
So here's a story from way a long time ago. I worked in the elder law unit and the elder kept smoking cigarettes in the apartment and was worried that they're going to set a fire. And everybody met and said, okay, this person is losing cognitive ability to take care of themselves. How are we going to preserve this tenancy? They took the stove out. They provided sand buckets. The idea is you solve the problem with human services providers, with management, with people who are in the group of how do we approach this? You don't say, we don't have the resources to figure out how to, there's a one in, if somebody's making noise, maybe noise muffling can be provided. There are ways to solve the problems. Is there a universal way to solve the problems? No, these are human people, human problems. They all need individual solutions and services to solve them.
Thank you, Jean. Thank you so much.
Thank you very much.
Kathleen, you're up next. You may have to make some adjustments in our schedule.
They just don't secure them.
Made the similar chuckle as I
attempt to set up a situation. Hopefully not, but.
Oh, mine, it's just, oh, Brian.
I'm wondering whether we should ask Brian instead of starting at 30.
I think he
Oh,
drove
that's
all the
four.
way,
Oh,
no, I
that's right,
think
he
he
drove here,
drove
yeah.
all the way here to testify.
Okay. And that we have house four. Well, we'll just have to see. I don't think we're gonna have time.
He does, yeah, because he doesn't live locally, so.
Yeah. Have to see. Kathleen, you should feel free to make your full presentation and we'll just have to adjust our times. I know, but it's, yeah. Just don't know where we're gonna put them.
I'm saying is this,
We could do the, what, this one here, look, use this.
oh, I'm saying if these two get,
Yeah. Right, to here,
yeah, sure. And these are virtual.
yeah, and these could be or not. Okay,
That's just
maybe
the
that's what we'll
paper.
do, yeah.
Oh, you wanted to share chips with us too?
Here it is. Let's see how it goes, but one possibility is to move this and move these.
Are you all set, or you need to get the Zoom link?
Just a question, do I need to pull the presentation up before I open the Zoom link or Zoom and then, okay.
Close that lab.
You don't have the time, but yes, that. Here. I like. Thinking so much. I mean, really.
Get pizza, but.
Oh, look.
Share your screen.
Yes.
Wow. This chair, that. Previous chair.
With, say,
Good afternoon. Thank you for inviting me in today. Again, my name is Kathleen Burke. For the record, I am the Executive Director of Clemens. Oops, I'm really having a hard time here. Maybe I'll just read from my, well, maybe.
Is it jumping around on you?
Could you help her one more time?
maybe we should just. So my presentation today is really an overview of the impact on federally assisted tenants. Okay. H772 introduces significant supports for renters, including eviction protections, increased confidentiality, credit building pathways, and VSHA managed funding. At the same time, several provisions may create challenges for households receiving federal housing assistance. Understanding these impacts requires examining the bill through the lens of federal program requirements that often govern federally assisted tenancies. It's important to understand that federal regulations always preempt state law in HUD-funded housing programs. Alignment is essential to protect program integrity and ensure continued receipt of federal funds, prevent conflicting obligations for landlords, and safeguard thousands of Vermont households that rely on federal housing assistance. Challenges and risks in H772. If not aligned with federal requirements, certain provisions in H772 could unintentionally accelerate court timelines beyond what federal due process allows, create strict cure requirements that conflict with HUD standards, permit owner use. Let's see what my permit owner use or renovation terminations that violate federal good cause rules, allow rent increase processes that destabilize vulnerable tenants in tight or high poverty markets. The following slides detail where state and federal requirements currently align and where conflicts arise. H772 supports several objectives that are consistent with federal policy, reflects federal good cause expectations for lease enforcement, reinforces health and safety requirements similar to federal habitability standards, establishes security deposit limits that can improve access for voucher holders, supports confidentiality practices consistent with federal screening requirements. Potential conflicts with federal regulations. Specific provisions risk conflict with federal housing law. No cause terminations contradict federal good cause rules for assisted tenancies. The 3-day criminal activity notices may not meet federal due process timelines. Non-payment standards do not distinguish between tenant paid rent and PHA paid rent. Federal law prohibits eviction for non-payment of the PHA portion of rent. That's the housing assistance portion of the rent. Trespass and removal rules may interfere with tenants' ability to meet program obligations or receive required accommodations. Key recommended exemptions. Prevent compliance problems for both landlords and tenants, VSHA recommends creating exclusive statutory exemptions for all federally assisted tenancies regarding no cause termination provisions. Clarifying that federal requirements govern eviction, notice, and due process procedures for these households. These exemptions provide a simple and effective way to prevent conflict between state and federal rules. To maintain program integrity, H772 should specify that landlords may not evict a tenant for non-payment of a PHA paid portion of the rent. Ensure court timelines allow federally mandated due process protections, including time for contesting termination actions. In this context, termination actions relate to the termination of a subsidy. These clarifications support fair process for tenants and legal clarity for landlords. Disability-related accommodations. To remain consistent with HUD's civil rights requirements, H 772 should include explicit language requiring reasonable accommodations for tenants with disabilities. Apply these accommodations to property removal, trespass orders, and other provisions that may impact a tenant's ability to comply with program requirements. Summary of recommendation. To ensure alignment between state and federal law, VSHA recommends adopting clear exemptions for federally assisted tenancies. Distinguishing PHA paid rent from tenant paid rent and non-payment actions. Preserving federally required due process timelines. Incorporating explicit disability accommodation language. Together, these changes support both tenant stability and landlord compliance. Rental Arrears Assistance Fund. This is an appropriation that is outlined in this bill. And I just want to raise for the committee's attention, in fiscal year 2025, VSHA received $2.5 million to create the Rental Arrears Assistance Fund to prevent evictions for sustainable tenancies. This fund, authorized under H 829, provides targeted assistance to stabilize households and reduce court-based evictions. This is a snapshot of funds spent to date. This illustrates that we've cured 188 evictions, spending about $1.5 million, and then you can see the county breakdown. H 772 proposes $1 million to continue the program past May of 2026. Without continued funding, the Arrears Assistance Fund will sunset when current appropriations expire in May of 2026. Continued investment will sustain eviction prevention capacity statewide. Thank you for your commitment to housing stability in Vermont. VSHA looks forward to working with the legislature to ensure that H 772 strengthens tenants' protection while fully aligning with federal requirements supporting families and landlords across the state. And attached to this presentation are two appendices where I've outlined where H 772 aligns with federal law, and then the areas which there are potential conflicts along with recommendations.
I just want to say, I took the liberty of forwarding her testimony to our council. And he's acknowledged receipt. Kathleen knows that that's occurred. Kathleen, just one thing, and then I'll go to your question. We just heard testimony that at least several years ago, there was a problem with landlords refusing to accept Section 8 vouchers. Is that still a problem?
I do not necessarily agree that landlords are refusing to accept Section 8 vouchers. We have gone through a period of time, certainly the pandemic era, where, landlords had more choice, and it was more difficult for tenants to find housing. But, we have a very strong landlord base that we work with, and we have landlords that call us, that work with us to let us know that they have apartments available or becoming available. So I cannot agree that landlords are refusing vouchers
At this time?
at this time.
In fact, the problem isn't it not enough vouchers?
Certainly, there's not enough vouchers. And to your point, I'm not sure who raised the question earlier during Jean's testimony. There is a Vermont protection. It's illegal to discriminate against recipients of public assistance, right? And so, in the work that we do, working with landlords and tenants, if we identify
that situation to be occurring, then we make the appropriate referrals.
By the way, just as an aside, and then we'll get to questions. Do you remember we sent a letter to appropriations advocating $5 million in the BAA for assistance? It was in the BAA and passed out of the House. We'll see what happens in the Senate. Yes, no, Tom and then Ashley. Or
Tom, Gail, Ashley.
Tom, Gail, Ashley.
Federal regulations perhaps stay on all HUD-funded housing programs. So when the subsequent slide, we're talking about federal regulations. These are all regulations that apply to HUD-funded housing or federal regulations that apply to housing.
My testimony is through the lens of HUD federally assisted housing.
Follow up, then, a Section 8 voucher. If a person has 3 units and then somebody comes who has a voucher, it's illegal for them to refuse the voucher. So they, it probably because they're also just nice, but just they have now one tenant with a HUD voucher. Does that bring them also? Does that then make them a HUD funded housing?
Yes,
Okay.
yes,
But for all the tenants?
So-
not for all the tenants.
Okay, so, so
So-
governing their relationship with the one tenant, it follows.
It's the subsidy that dictates. So the voucher in your example dictates that landlord comply.
With the.
Right, but if it's an entire building and there are several, properties where the entire building has Section 8 assistance.
Right.
Then the entire building, all the tenants would be protected in that way. And so the biggest differences from my review of 772 are the notice requirements and then due process protections that participants in federally funded rental assistance programs have. And so, a reason that a family might lose their Section 8 voucher is if they are evicted from their housing, okay? And so there was a question I think raised yesterday with regard to are owners required to notify the Public Housing Authority by sending copies of termination notices to the PHA? And yes, they are required. The requirement is there so that as we're notified that action is occurring, we can intervene and begin working with the family ultimately to prevent the eviction. But if a family is not paying their rent and they're moving toward a non-payment of rent situation and they're at risk of eviction, if we put that family on notice that they're violating their program obligations by not paying their rent, we have to give them an opportunity for a fair hearing. So we can't just take a family subsidy away without giving them an opportunity for a fair hearing, for an appeal, and that takes time.
Gail.
My question before is if I own a duplex or quadplex and I want to rent as the owner and someone comes to me and they have a voucher and I refuse to take that person to rent that space, that's illegal?
You have to have a legitimate business reason for not accepting that tenant. You can't simply say, I'm not going to rent you because I don't take Section 8.
So you would say something else.
Well, hopefully as a landlord, you're doing background checks and suitability checks, and there's a reason.
Debt to income ratio.
There's reasons that you've decided that you don't want to rent to this tenant.
Mhm.
It cannot be because they have a subsidy. That's a violation of the law.
Thank you.
Ashley.
I just wanted to give a shout out to CBOEO because they're still in the room. But I learned all I know about Section 8 subsidies in the fair housing training, and it was fantastic. And I think it is a great program for both tenants and landlords. So thanks for all you do.
Yes, Debbie.
Well,
When you talk about the federal, like the section 8 and the federal, would that be like, I think in the federal law, you have to give a 30-day notice, like
That's
right now,
correct.
we have a 14-day notice in Vermont for termination for whatever reason. So if you had the section 8 person, you'd have to give a 30-day notice.
That's exactly the case. And I'm not suggesting as you're crafting, revisions to tenant landlord law, 772 or whatever it might become, you just need to be cognizant that there are federal requirements that are going to prevail depending on the unique situation.
This is something I would say is a drafting problem that's pretty easily dealt with. And also, just from my own experience, like I said, I was heavily involved in the East Calais store project, which had 3 units of housing above it. And that project was entirely subject to federal law because we received, it wasn't because of HUD, it was because of federal tax credits that made the whole renovation possible. So we just knew we had to look to federal law. For example, we knew we were going to be responsible for relocation of the tenant who was there when the renovation began. So we knew we had to follow federal law. And I think what Kathleen is saying is it would be really helpful in whatever we do, 772 or whatever emerges, if we make it really clear so that it won't be confusing to landlords. I will say that I think we as a landlord and a lot of landlords really want Section 8 because it's guaranteed income. In other words, if you're going to rent to a tenant and you've got a Section 8 voucher that covers 3/4 of the rent, you're in better shape perhaps than in other situations. Yes.
Am I okay to be next? Did you already ask?
Good.
I lost track, sorry. The question I have, and I don't know if it's a question for the SHA, but these requirements that seem very strict are a higher threshold than what we currently have, than the operating general non-Section 8, non-federally funded housing, right?
Right.
And I guess, sorry, and just to follow.
Sorry.
So my question is, like you just pointed out, the pro of engaging with that, it's optional for you as a landlord, I guess, to rent at all. But then when you have this person, a tenant who comes with a voucher, there's going to be a financial incentive of, you're going to get paid, it's going to be, right? And then there's this con of maybe you have to live up to certain other standards as the landlord who's getting federal funding. And so I guess I'm just sort of stating the obvious, like if it's working for a huge proportion of our housing, of our landlord tenant relationships in the whole country, right? Will it be as destabilizing and tough as we hear? Like I'm trying to get, from these stories of this is going to ruin, any kind of standard is going to ruin our rental market, to, well, if we already operate a large proportion of our housing based on these standards and it has not entirely ruined our market, then.
Is this a question?
Yeah, no, I warned you that it may be.
I think you're
Not a
making the point,
question,
you're
but
making the
I'm
point that
making
the federal regs set a higher bar and maybe we should think about that, right?
Yeah, I guess, do we know what the proportion is of how many of our housing is
Oh, we certainly have. that
Has to go to
statistic.
federal-
You know,
has to abide
aggregated
by
for the
that.
state, I don't have that metric. The Vermont State Housing Authority assists about 8,000 households. Do you have that statistic?
It's about 15,000 households.
Can you just state your name back again?
I'm Jean Murray from VLA. There's about 15,000 households. So the housing that's funded with LIHTC, low income tax credit housing, which I think is one of the things. Those regulations are from the Internal Revenue Service as opposed to from HUD. So, but there are regulations. They're different ones. So I'm not sure how many LIHTC houses there are.
I can certainly report that back to you. The number's available. I just don't know it offhand. But I will clarify, you know, it's the housing provider and the landlord's responsibility to comply with the more stringent standard, the federal requirement. Right?
Yeah.
By participating in a federally funded program. Where I am a bit concerned, just from a public housing authority perspective, is the shortened notice requirements and in making sure that as a public housing authority, we're receiving those notices promptly and that we're able to take the necessary steps that we're required to take and that participants receive the right due process that they are entitled to.
Tom?
So an open question to those of you that are here. I don't need an answer right now, but just partly to address what I'm really trying to do here, which is
A little louder, Tom, yeah.
we're responding in part to the number of small landholders who have an apartment over the garage or one or two places who are afraid to rent long-term. And even if, I think it is, but even if the situation is not as dire, these are people who may need to rent that apartment in order to keep their home. But they are afraid that if they get that one bad tenant out of 40, they lose everything. And even if it's just a matter of perception, these people are staying out of the market. And if I recall from the HFA's report, we're talking about a 5-digit number of rental units. And one of the problems we are having is we don't have enough units. So how do we win the confidence of some of it, even if we bring 500 of them back online? How do we do have to think about the relationship and the communications to kind of reestablish with, and I'm not so worried about the 100-unit building as I am about the little places, especially in rural areas where there are not high rises full of apartments. So we have a challenge to kind of reestablish
Oh, he's outside, you should bring
their
it.
willingness to not put things in short-term rental, or just keep them off the market. So there may be a better, I'm open to suggestions as to how do we, even as agencies, rebuild that bridge so people are like, yeah, I can do this. Because right now, we're trying to address some things that are keeping units off the market.
Yeah, I mean, that's a very good question, and I'm sure we all have our own unique response to that. You know, I will tell you that within the Vermont State Housing Authority's program, about 50% of our participating landlords are private mom and pop landlords. The other 50% are nonprofit landlords. I think from my observation, nonprofit landlords do a pretty good job at tenant selection. They're making good choices to the best of their ability. It's really the smaller mom and pop landlords that may not know the law. So it's not necessarily intentional that they're not following it, but there are issues with that. They may not give the right notice. They may not provide the public housing authority with a copy of a termination notice. And so they go to evict the family and that eviction gets thrown out because they didn't follow the proper notice requirements. It's really, I think, more education, more training, and this is really why I'm recommending to just make it clear in whatever language you adopt that that federal law will preempt state law in these areas. And so it's absolutely clear.
Well, thank you. And I appreciate very much your testimony. Our next witness is here.
Okay, could I just make one clarifying
Please.
Statement before I leave? And so Jean in her testimony had referenced 70% of the vouchers at one point in time were not being used. That statistic was that our success rate at that time was 70% of our voucher families were successful. What that means is if you have 10 vouchers on the street at any one time, 7 families were successful. Vouchers still went used, just was an added burden to the Public Housing Authority because they just would put a ton of vouchers on the street and have a lot of searching families to ensure that the assistance was being used, but it was the success rate.
I just have a quick question. Isn't it true that vouchers were returned because people couldn't find apartments to rent?
So that is all tied into the success rate conversation, and I'm happy to talk with you more about that. I'm sensing I need to get out of the hot seat. Thank you.
Kathleen, thank you so much.
Thank you for keeping it warm. Good afternoon, folks. I was actually in the cafeteria trying to respect your process, so hopefully it wasn't viewed as being tardy because I will respect it.
No, don't worry about that. Please, when you have a minute here after everybody gets out of your way, please sit down and tell us your name for the record and tell us what you have to say. And welcome. Oh, but you know what? You haven't been here. Starting with you, Debbie, why don't we'll introduce ourselves to you?
Thank you.
Yes. I'm Debbie Dolgan. I represent St. Johnsbury, Concord, and Kirby.
Thank you, Debbie. Pleasure to be here.
Hi, Tom Charlton, Athens, Chester, Grafton, and Linden.
Excellent.
Joe Parsons, Newbury Tops, and Groton.
Lodge, Essex Town, and City of Essex Junction.
Born and raised in Essex.
Oh, best place on earth.
Town on 10 feet.
I saw some skid marks on. Near Maple Street Park.
Maple Street Park, it's got double mohawks, Liberty spikes, so you may not recognize me if we cross paths. Costumes change, but the thoughts are the same.
Actually, Bartley, Fairfax, Georgia.
Welcome, I'm Mark Mahaly. I represent Plainfield, Calais, and Marshfield.
Hello, Emily Krasnow, Chittenden 9, South Burlington.
Hello, I'm Mary Howard and I represent Rutland City District 6.
Welcome, Gail Pezzo, Chittenden 20, Colchester.
Saudia,
Hi, Saudia Lamont, and I represent Lamoille, Washington District.
Excellent. Thank you. First, thank you guys very much for having me here today. My name is Brian Armstrong. I'm a born and raised Vermonter. I swore when I was growing up, when my hair was in mohawks and Liberty spikes, I was going to leave this small state and never come back. I've never left, and I'm hard pressed to leave. I absolutely love the cold and I love our community. I've raised 2 amazing families in the state. I'm the principal broker of Keller Williams Vermont, which is one of the large real estate companies in the state. I'm also one of the operating principals and co-founders of Strongwell Property Management, which in the Burlington area manages, give or take, about 260 rental properties. I'm also an operating principal and co-founder of Lake Champlain Closets. I've been in business with both my amazing wives. Hopefully I'll never have a third business with a third wife. Best of times and worst of times. I'm also a co-founder of Magic Man Cannabis, which is a vertically integrated cannabis company in Essex Junction. And one of the things that I'm most proud of, besides the fact that I've worked 2 jobs most of my life for a job and a half, is not so much the companies I've helped create, but the impact that we've had in creating sustainable jobs, most of which have benefits, and the impact that we've had in housing through increasing homeownership through Keller Williams Vermont, or providing safe and reasonable housing to our renting residents. I prefer renting residents over tenants because I think it's a little bit more human of a statement. I can be occasionally precocious and bloviate, but the reason why I asked Emily to bring this beach ball and I brought her that is this comes from one of the most impactful books and courses that I've ever taken. I actually got certified to teach this course. The course is called Fierce Conversations, and it argues that most people see that truth is black and white, when in fact, it's more like a beach ball. Because you're sitting on one side, so you're seeing the green stripe, that's your truth. You're seeing I'm partially colorblind, I think that's orange. You're seeing the orange stripe. The other reason why I brought it today, and I hope we think about it as we go through it, is because the beautiful thing about that beach ball is we have a problem here and a challenge here that we're all stakeholders in. And like that beach ball, I think we all have a role to help fix it. With candor, and forgive me if this sounds a little bit conceited, I've worked extremely hard in my life. I'm not here worried about Brian. Don't get me wrong. There was 3 times I thought about getting out of the housing business as a renter. Once, when I went into an apartment that I owned with 3 Winooski police officers and saw more needles than I ever thought I'd see ever, let alone outside of a medical facility. The second time, when I had a tenant who was so challenging and verbally abusive to the fellow residents that it took me a year and a half to get them out of the building. Side note, the other residents were so kind through that entire process, I cooked them ribeyes when I got that person out. The third time I thought about getting out of the business was when I read about $3.99, $4.40, and $7.66, and some parts of $7.72. And here's why. The hopes that I today leave you with is I'm concerned about some of the impacts on homeownership, the inverse and unanticipated consequences of some of the programs being discussed, ultimately furthering the wealth divide. Homeownership, the primary, I think in the 1980s, the average age, and don't quote me specifically on the number, it should be pretty close, 1980s was 28. It's now 38. Homeownership is a dream that's starting to disappear for our youth. So I'm here today for the next generation of Vermonters, my 2 amazing grandsons, and the 3 amazing stepchildren that my 2 different wives brought me. So I thought it might be helpful to promote equality, not massively pro-tenant, not massively, which I do think it's very pro-tenant right now, it's pro-renting resident. I'm not looking for or promoting extreme landlord protection. For example, I hear, and I don't know this to be fact, that New Hampshire, it takes about 30 days to evict somebody. In Florida, it takes about 30 days to evict somebody. I think that's too fast. But right now, I am seeing a 6-month process on average. And I think if we're not careful to correct that, we are going to see one of the most valuable partners in this beach ball we call housing get out of the game. So I thought it might be helpful, I want to respect your time, to tell 4 brief stories. First, name was Laura. If I get a little flummox, I'll explain why in a second. She was a daughter of an alcoholic construction worker who happened to be a Marine. Laura lost her mother unexpectedly at the age of 13. Her first marriage, and I was her second for the record, I just told you who she was. She left an abusive first marriage with a firstborn of less than 2 years. Despite being a single mom, she found time to be a guardian ad litem. She worked a job and a half, both at the Stowe Reporter as well as she waitressed in Stowe, so that she could provide a life to her son, Jackson, who became my stepson. Laura worked extremely hard to save 3% so that she could buy a house with the Federal Housing Administration. And one of the great things about the FHA program, I used to be a loan officer as well, is you can use 75% of rental income to qualify. Laura could have never bought a house. She could have never bought a condominium as a single mother. It was the opportunity to buy a multifamily property that helped this person build a future for her son, a retirement for herself. Laura was headstrong and stubborn. But at the same time, as much as she was a risk taker, I cannot tell you in good faith that she would have bought a duplex in today's market. Not because of the affordability, but because if a single mom barely had 3% to close, and then she had one non-paying tenant for 6 months, she would have destroyed her credit, which is something that was extremely important to her. She would have been able to make, and I can tell you this, no repairs during that time. So no cause eviction, I think, is an extremely important tool. I'll talk a little bit more about that if you give me time down the line. But it's also a reason why I think the current state of affairs simply does not work for housing providers. And my greatest concern, again, is we will see the small housing providers get out of the game. And if that happens, I think you will be left with big corporations that can afford to carry units empty, that will operate like a machine. You either meet the qualifications or you don't, versus Laura, and at times myself, who would like to take chances, but we took chances knowing it was on average 3 months to get somebody out. So the second story, and for the record, Laura passed just under 10 years ago. Winnie the Pooh, how lucky am I to have something that makes saying goodbye so very hard. I will tell you, and I know this is not a part of 772, Peter saw me. One of the things when Laura was first diagnosed with cancer, which bear with me if I get weepy eyes, amazing, I've been blessed with 2 amazing wives. I was driving to a doctor's appointment and my mom was taking me and my stepfather. "You gonna be all right? You know, cancer, anything, you guys need any money?" I said, "Mom, I've worked a job and a half, 2 jobs all my life for moments like this. I'm good." So as a side note, when I read thoughts about rights of first refusal, I could not have imagined recognizing my spouse is likely going to die with cancer. If we needed money and I had an investor who was going to buy it like that, and you go to market and wait for a first right of refusal. I mean, it makes me cry. Second story I'd love to share with you. First gentleman's name, leave it at that, Mohammed. Laura and I worked a lot with the refugee resettlement program. It was a great program. I love the fact that we were welcoming new Americans in that had a real flavor for the dream of, excuse my language, bust your ass wide open, provide for your family. I'll try not to swear. It's one of my weak spots.
Okay.
Kicked out of Rice High School in 2 days because of my haircut. So I did it.
I'm sure you were shocked.
So we used to love working with the refugee resettlement program. We would take it. We knew we were taking a gamble. We knew again at the time it was about 3 months to get somebody out. We also knew that we had no cause eviction if it wasn't working. Now, Muhammad and I think he left our buildings 12, 13 years ago. Today, he's a manager for JetBlue. I see him when I fly through Burlington Airport. When he found out Laura passed, you could tell he was like taken back because he knew we gave him a chance that nobody else would have given, or not many people would have given. And I think he's a great example of why landlords need to be empowered to take chances. But to take chances, you have to have reasonably quick exit strategies for 2 reasons. We know this. 1, I take my credit very seriously. 2, if somebody's not paying us, we can't make repairs. Now, as a side note, of the 260 units that Stronghold Property manages, my stepson Jackson from Laura and I are business partners in those buildings. We probably operate 27 of our own person. But think about that person who owns a duplex. One person's not paying them, 50% of the cash flow's gone. 4plex, one person's not paying them, 25% of the cash. And I can assure you, this is not a 50% margin business. This is not a 25% margin. If I had to guess, our margins have gone down over the last few years, which is part of the reason why I took a volume approach. Now, again, I think it's essential that we retain no cause evictions, timely processes so landlords take chances as opposed to just operating like machines. Third story I'd love to share with you, John. The Dalai Lama would say that we're all masterpieces in the making. John, I have no doubt, may have had a little bit more opportunity for making than others. John lived in our 4-unit apartment building, and while he was respectful to me, he was often dismissive, rude, and chauvinistic to my first wife, Laura. He would have a threatening posture. Now, for the record, as a daughter of a Marine, I've worried more about John and altercation than Laura. But Laura was a unique person. I cannot say that for a lot of the people I've worked with through the real estate brokerage that could happen. We even brought the fire marshal in on our own building. We said, please help us. We're concerned that he is becoming a hoarder and he's a fire hazard, a pest hazard. And I hope you probably would agree with me. Not every landlord invites the fire marshal and for them to. I hope you see somebody today that you sense, yeah, I'm a little bit of a risk taker, I'm an entrepreneur, I love the state, but I want to do the right thing by people. I'm the one that's going to die when it's time for me to die, so I want to do that with a clear conscience. We even reached out to the housing authority to get John help. He refused to participate. No cause eviction was essential because what started to happen was his belongings were spreading across the yard. Other tenants were starting to complain. Other tenants were starting to have combative discussions with him. And as much as I believe we all have a right to a day in court, I could have seen that if I had to go through a full eviction, you could clean it up one day, gets nasty the next month. But then when I go to rent the building, people would look at all this stuff and say, I don't want to live next to this person. And so it would have put me in a position where I can't rent to tenants who want to be part of a positive community. I don't know if I should sell the building at a loss because it'd be hard to sell if it didn't have good people in there. And again, it was not, I have a sense that sometimes in this conversation, my friends on the other side of the aisle, and they are my friends, possibly as Vermont Legal Aid, are so focused on their stripe of the beach ball, they're only worried about the renting residents. Whereas I'm trying to look at the entire beach ball because we've got to have great tenants' rights, we've got to have legal aid to defend people against the nasty landlords that happen. We've got to have equitable opportunities, not only for the landlord, not only for the tenant, but for the other residents who aren't going to speak up in these hearings. So eviction or no cause eviction was an essential tool, not only to protect the community in that building from the risks that was a significant hoarder, but also for us, Laura and I, to continue being small housing providers. Expenses. I live a modest life. I worked two jobs all my life. I drive a used car. My wife drives a used car. I recognize I'm not going to have a pension. I was an IBM brat, and IBM taught me that no longer exists in most places in our world. You can go work and get a pension. So I chose to work extra jobs to prepare for my future. Side note, Warren Buffett once said, if I offend anybody, please let me know so I can grow. If you're born a white male in this country, you won the ovarian lottery. Some people may not like that statement. I think Warren Buffett's a pretty smart guy. I recognize I won the ovarian lottery, right or wrong. So again, I'm less worried about me. I'm more worried about other people want to get into homeownership and provide housing. So we own a 6-unit property in Winooski, and I love Winooski. I love the community. I love the diversity. I love the town. They work with us. Great place to buy property and a great place to participate in housing. In that building, I have a tenant, last names remain nameless, named Donna. They have been with us 20 years. I even try to help them buy a house because, no disrespect, you're paying down my mortgage. I think you should pay down yours. They just love the convenience of renting. I have long kept Donna's rent well below market because she is, excuse my language, a damn good tenant. She's a damn good human being. Checks in with me still when she stops by KW to pay her rent. She asks if I'm available, and it's just great to talk with her. Winooski raised our property taxes 13% in 1 year. I had no other choice but to raise every unit $100 a month just to break even. One of the reasons why I started a property management company is because if you're looking for someone to hang a door, change a toilet, good luck. If you want to renovate a building, oh yeah, you'll get plenty of bids. Our property management company provides benefits. We provide a 401k. We are struggling to find the talent necessary to fix our clients' buildings, let alone ours. So when I have to raise a unit $100 a month just to break even on property taxes, that does nothing for our gas, nothing for the sprinters that we have our workshops in, nothing for the payrolls, nothing for the increased cost of Vermont gas. So the question I ask open-endedly is if I'm capped at, is it 8% plus 3, 5 plus 1 of the various proposals that I see? And that doesn't allow me to keep up with the expenses. How many years do you expect a housing provider to stay in the business before their margins are gone? With a polite poke to amazing legislators in this building, if the state can't keep their revenue on taxes to 8%, why are we asking the very housing providers or penalizing them to do that? Again, we couldn't, under that current, I think I'll stay in the business. That was a side note. I shouldn't tell you this. After my first wife died, I bought a motorcycle. Every now and then I may hit 3 digits. I've stepped out of helicopters with a snowboard on my feet. I am a risk taker. I don't think people have as high risk tolerance as I do. So I'll play the long game because I love providing housing and I do believe in the value of real estate.
Do you have a question here, Ashley?
I'll let you think.
Almost done on thoughts, and then I've got various thoughts on these. I'll admit, I am challenged by the mayor of Burlington. Why? Because with everything that's going on, as a cat lover, I heard she might want to leash my cat. I said to her at a meeting one day, I told her about the story of this Winooski building. And her reply was something to the effect, I don't think landlords should be able to evict people just because they can't pay increased rent. With humor, if I don't pay my taxes, what happens to me? I'm evicted from the ownership of the building and all the equity that goes along with it. Well, I have other thoughts. I sense I want to respect your time to answer questions. To me, rent caps set and imposed by this legislator will also equate to guaranteed rent increases every year. And I will tell you right now, I will do that because I'm concerned that if I can only raise rent X, and then there's a couple good years, property taxes don't go up, everybody's getting along in Washington. If I don't raise rent that year under a rent cap, but then the next year there's double digits expense increase, I'll have to do it. I'd rather deal with the market. Now, I think it's Allen Brooks, which does a study on the Chittenden County real estate market, which said the vacancy rate in Chittenden County is at a record high of 4.6%. Rents are starting to come down. I have never seen Burlington's rental market have more than a 2% vacancy. So I think the market is starting to stabilize. Side note, part of the reason being, I also think we have a lot of these new big buildings coming up. I'll also mention on that note, being able to look at a credit bureau of a tenant or renting resident allows me to take an educated guess. If I haven't been cut off, I will tell you another quick story. I one time looked at a credit bureau, wasn't great. People were super nice. They were following up, they were quick, they were responsive. I'm like, these are good people. I rented to them because I knew the whole picture. Whereas if I can't look at their credit bureau, I feel like I'm making a decision like this. Now, I said to those people, if I have to chase you every month, I said, one, I'm only going to do a 6-month lease. You seem like good people, but based upon your references, I should not rent to you. But I'm going to take a chance. But if I have to chase you every month for rent, I'm not going to renew this because I can't be banging on your door instead of spending time with my son. Sure enough, I chased them every single month. 170 North Winooski Avenue, I think it was April or March. We had a conversation at the end of the lease. I said, folks, you just didn't hold up your end of your bargain. I'm not renewing it. You know what was great? They honored their word. They said, you're right. We'll move out. Take these tools away from us. And I think the road to hell is paved with good intentions. And I drive a mean paver. You are going to eliminate I think what is essential in our community, the small housing providers that will operate with heart. Now I can go on for hours, but I understand my name is not Cory Booker. This is not an opportunity. I've got other thoughts, but I want to respect your time.
I appreciate it. We are gonna turn it over to the committee for questions. We have floor at 3:30. I'm just reminding people. So I'd say we have about 7 minutes worth of questions. Yes and yes.
I can be really quick. It's obvious that you looked through some of these or bills that we have in front of us. I guess my question for you, as we as a committee sit together and are trying to solve an issue that has, I think, as you said, with your beach ball, more than two sides, is the status quo potentially better than the unintended consequences of these bills? Is there one bill that you would move forward? Do you have any thoughts on that?
So absolutely quick, the status quo is not working. I heard, and I would encourage you to check this with Bar Association. Less and less attorneys are doing evictions. I was looking at help, I was gonna buy a building 2-3 years ago. Older gentleman could not afford to make the repairs that need to be remade. I was gonna let him stay X number of months. It was gonna be a very equitable situation. He could not find the lease that he had with the upstairs tenant. My go-to eviction attorney said, Brian, I'm not taking it on. It's gonna be too much of a court case. And so in that situation, a senior he probably ended up, I don't know what happened, I'm gonna guess he ended up getting foreclosed upon. Lost any and all equity versus the probably $25,000 to $50,000 he would have walked away to help him in his next place. Burlington lost the opportunity for a good landlord to bring property to reasonable condition. So I absolutely think it's not working. I will tell you, if some of the bills that are in here, and with candor, and my goal is to learn more AI did a summary impact of all these bills. I didn't know if it was right. With ChatGPT. I will tell you, if some of the one-sided pro-renting residents that don't consider the size of the small housing provider go through, I can guarantee you, there's going to be a glut of multifamilies in the market. Last month, I think there was like 12 months of inventory across the state. Side note, single families, probably, I think 4 or 5 months. There's two issues there. There's a lot less people getting into the game, and I hear this from the brokerage side because I never want to deal with a tenant. I hate to take 6 months to get somebody in. I can't afford that risk. Then the other issue you have, which is not this committee's, is there's a lot of landlords that bought properties with 3.5% interest rate and 6% capitalization rates. And they're understanding why nobody's going to buy their house at a 6% capitalization rate when they have to finance it at a 6.5% rate. So some of that. So no, I don't think I think if you don't do something, you're going to lose a valuable part of it. But don't forget again about home ownership. Now, this is going to sound harsh for a second. National Association of Realtors research that the average net worth of the renter is $11,000. Peter, am I on that? Average net worth of the homeowner is like $400,000. Now, on one hand, somebody might hear that and say, well, you're just saying screw the renters. No, I'm a conscientious capitalist. The capitalists we have in Washington right now are unsustainable. It's all about profit. It's all about efficiency. As opposed to, I think it's a great book, Do Less with More, that talked about the best capitalism focuses on the community and resiliency of the market. I will tell you, if all the one-sided to my friendly renting residents and my friends on the other aisle, legal aid, go through, I'll consider getting out. Or I'll consider, this might help housing, condoizing buildings. But that's still going to take renting out of it. With candor, yes, if you own real estate a long time, it can be a very good investment. But it is not, let me buy this and tomorrow I'll order my Bugatti. If anything, you're going to take $400,000 worth of gamble. You might make a few $100 a month. And by the way, get calls in the middle of the night, deal with complaints. I just closed on a building, owner financing. It's going to take me a year to get the thing profitable. I know I have to look at replacing heating systems because it's one heating system and a tenant's complaining her unit's too hot. That takes time.
Yes.
I'm gonna ask you to dig deep into that, jumping out of the helicopter spirit, and say, I've heard you loud and clear about those measures, and those are various measures that are in 772, right? Capping, rent increases, et cetera, et cetera. Is there anything, but I've also heard you say we can't stay the way we are. And so what would be the risk that you would want us to take? What would be the risk that is worth taking?
Here's what I would say, and this, I don't know if Emily asked me to put some thoughts and homework about what.
I gave him homework.
And I still need to, I was never great with homework. I was a BC student.
It's
maybe
due
B.
now.
Okay.
Surprise,
All right, so
pop quiz.
here's my can. One,
Whatever you got.
leave no cause eviction in place. Do not honor any of the requests met. Because again, it looks great on the surface, but I've never met a good tenant who I would no cause evictions. No cause eviction helps me get drug dealers out of the building, helps me get violent abusers that are disruptive to the rest of the thing, or that person who's a hoarder.
I have to interrupt and ask you a question, excuse me. The reason I'm asking the question is because these terms just cause and no cause are simply summaries. So let me ask you, when you say no cause, you mean the ability not to renew the lease?
The ability not to renew the lease.
Okay, do you mean, for example, the ability to convert it if the landlord wants to put their family in it?
I do believe that is also something that should be protected.
Do you think that if a landlord wants to repurpose the building for something else, say condos or whatever, they should be able to? Is that part of no cause?
That, to me, that is, although you can tell it's not my leading reason why.
Right,
I do
okay.
believe people buy real estate, it's part of the bundles of rights. And yes, I won the ovarian lottery, but candidly, I got in trouble with marijuana when I was 19. I'm an ex-con. I had a lot of corporations tell me they wouldn't hire me. Side note, now I have license to do the very thing I got in trouble
Yeah,
for.
I
I
heard
created
that.
23 full-time jobs with benefits.
Okay, thank you. All right, so go answer the question.
So
Yeah.
one, keep no cause evictions in place. Do not mess with a rights to pull credit bureaus, not, because again, I don't look at it for perfect credit. I look at it as like, what's the whole picture?
Yeah, we're not.
If you're gonna have a rental registry that has a rental registry of landlords, make that equal. Have a renters registry. Consider a course that is like a homeownership course. FHA has homeownership courses that says you're ready for homeownership. Maybe have a certification that, hey, Joe, Jane, tenant went through a course, they understand budgeting, they understand this. I would work with that group all day long. Probably, I would recommend this group do a couple things on notice. I think 7 days for non-payment of rent makes 3 sense. 3 is too quick. 10 is comfortable. Pause there. I've met only a few tenants who I sense didn't care about paying. Most tenants want to, they're gonna tell you, I'm gonna catch up. They have to look at, do they have the ability to catch up? And I'd rather work with them to help them next place. Take a look at keeping evictions to 90 days or less for the entire process. Personally, I prefer 60. I think 60 is the equitable spot. 30 is too fast. I think because there are bad landlords out there who don't care about being responsible citizens. 60 is really where I think it should be, total process. 90 is stomach. Other things, I would be careful about the tit for tats that happen, when evictions start and the tenant says, well, this isn't working. I'm not as involved with the day-to-day management anymore, thanks to a great team of people. But generally, when we think we have a tough eviction about to occur, we bring in the city inspectors. We get going on it so that it's taking that argument away. Inside note, it also proves we're good citizens. If I had other thoughts,
Doug,
please.
one thing. When you ask for a security deposit of a few months, right, of like the first and last, and then you get non-payment happening,
At 10:30.
is that not meant to, like, should there be a balance between, instead of just no cause, because that's my only short way to get somebody out? Could there be, that's another tool that I don't think a lot of people have mentioned about, like, that is in the bill.
So
about
let me play
security
devil's
deposit.
advocate to myself. Most of our units are in Burlington, so we're not allowed to take more. So we generally collect first month security deposit, and before we give you the keys, we need the full rent. I think that is equitable. Hard pressed, I don't know this for a fact, because you got a great general manager, you made part of the company. I don't know too many landlords who collect 3-4 months. I've heard of it, but we don't do it. So personally, if you put a clause in that says you can't collect more than 2, I think that would be equitable. But again, right now, we generally collect, I don't know if this is all for all of our 260 units, because we have some landlords that say, this is what I want you to do. But I think 2 months is very equitable. I don't think 4 months is, so that's hopefully pro renting residents. Because my argument with the problem with, well, if I collect 4 months, then I can just use it if you don't pay me rent. I think most Americans are troubled with $1,000 emergency.
I said that just today.
Yeah.
We're,
First wife's-
unfortunately, we are out of time. I hope that has partly answered, if not
But I
entirely
gave-
answered the question.
I gave him homework
Yeah.
and so hopefully he'll get that to our committee.
And but also what we're doing is that Michael Monty and Chris Donnelly
Oh, go
have
ahead.
No,
graciously, graciously agreed to testify tomorrow at 10:30. Terrific. Thank you.
Oh,
I appreciate what you guys are doing here today. I would like to earn the right to collaborate on more of this information because I care about this community and hopefully you sense I consider myself a fair and equitable person. But thank you very much for the opportunity to collaborate.